Hello. Today I'll talk about a subject which has gained ground in various high courts of this country. What we see today is a mushrooming of civil revision applications under Article 227 challenging various orders or any kind of procedural or substantial orders passed by an arbitral tribunal. Now, there is a section 5 of the Arbitration and Conciliation Act which restricts judicial intervention. The Supreme Court has always noticed that Article 227, being a constitutional provision, cannot never be ruled out. However, this practice of challenging orders of an arbitral tribunal by way of a civil revision has been questioned and deprecated by the Supreme Court. It has clearly said that the orders which are being passed by various high courts are not right and it cannot be done like this. An arbitration action is primarily by consent of parties a private forum, and there the law is very clear that you have to wait till the arbitration is over and then you can challenge it under section 34 with the limited grounds that are available there. Otherwise, you can always do something when you have a right within the Arbitration and Conciliation Act to challenge something under section 37 if one of those orders can be appealable. Otherwise, if there are other procedural things under section 13, 14, if it can be done, you may do so. But other than that, there is no option for any particular party, even if they have suffered some kind of a prejudice, but to wait till the arbitration is over and go along and file an application under section 34. No application under Article 227 can be filed. Though I'm saying this, but I'll tell you, it is with the Supreme Court judgment has recognized this in Patel Engineering way back, over a decade back. And so now Justice Nariman's judgment has also come in again, restating the same formulation that you should not be doing this. But even today, unfortunately, paying absolutely scant disregard to the law laid down by the Supreme Court, there are various high courts which are passing these orders. Well, there might be circumstances and there might be extreme circumstances. Well, those extreme factual circumstances apart, though that also is not covered under the Supreme Court law. You have to do it under 34 afterwards. But there is no real reason why there should be so much judicial intervention. The Supreme Court has clearly noted that the very aim of having an arbitration proceeding is to cut short the time limit. And now, after the amendment of Section 29A coming in and limiting the time of arbitration to 12 months plus a 6-month period if by consent of parties, there is no real justification that orders of an arbitral tribunal can be challenged and they may be taken up and entertained by any of the high courts under Article 227. Well, this is my feeling, but I'm sure there are better understanding prevails. But my understanding is that the Supreme Court has laid down the law very clearly. And if arbitration as a mechanism has to flourish, judicial intervention may be required, but not at a time when there are the basic orders are being passed in the arbitration process. It has to go as per the Arbitration and Conciliation Act. So wherever you find there is any kind of Article 227 application, civil revision applications being filed, my learned friends will always help our learned judges and members of the judiciary by showing the judgments in Patel Engineering, and there is another judgment of Justice Nariman which I will share in the comments, which clearly lays down the law that it is not permissible. Thank you. Have a nice time, and I hope you keep this in mind.